Okay. Welcome everybody to the World Forum on the Internet of Things. This is the fifth of our virtual events. We've had a IoT Day Slam jointly with the IoT community. We've gone through the technical papers, an entrepreneurial program, tutorials, and this part of the program and the two upcoming events deal sort of with the technical side of IoT. This particular week is devoted to standards, policy, legislation, open source issue, things along those lines. We've had two sets of presentations, Monday and Tuesday, and today we have four great speakers for you. They will be dealing with two important sets of issues. One of them is sort of the world of security and privacy for IoT. The other world is really sort of the landscape of what's happening on the legal front in IoT, and at the same time, I would say with an emphasis on the role that AI plays in the game. So with that, what I'd like to do is first introduce our speakers. What I'm going to do is, if we could start off with Anahit first. If you could just take a couple of minutes and introduce yourself, okay?
Thank you. My name is Anahit Tarkhanyan, and I'm platform architect at Intel and leading IoT hardware-based security product architecture. Joined Intel in 2011 and have extensive industry experience delivering security solutions product to the market. My expertise is the silicon-based edge to cloud system security, artificial intelligence, machine learning protection. Working very closely with the customer, driving architect to architect discussion around the security with our customers. I have PhD in distributed computer system networks, hold several internationally filed patents, and have publication in the field of the security. Working closely with my partner, Amit Elazari, she is here, and IoT security policy related issues that we plan to cover today.
Okay, so Amit, if you would like to introduce yourself, please.
Yeah, absolutely. Good morning, everybody, or good afternoon or good evening, wherever you are in the world. I'm really pleased to join you today here in this presentation with my fellow panelists and my great collaborator, Amit. My name is Amit Elazari. My background is both legal and technical. My doctoral degree is in the law from UC Berkeley, where I still teach in the School of Information, the Master in Cybersecurity program. I work around a variety of issues from computer crime, CCPA, privacy, security, intellectual property, contracts and the like. At Intel, I do government relations. So I work closely with policymakers around the world as they're considering regulation around IoT. But I also work very closely with my technical partners here on IoT security baseline. So I'm one of the editors of the international standards in development at ISO, at SE27, on device baseline security capabilities. I've worked with Anait and our business units at IoTG very closely to provide comments and work together with NIST on NIST 8259A, which you will hear upon today. And fun fact, I have some bug bounties from Facebook and Google for my work at Berkeley. I often collaborate with hackers, with security researchers on interdisciplinary work. And I'm really excited to be here today and hear also from my fellow panelists on some of the developments in this area.
Okay, super. Jennifer?
Hi, can you all hear me?
Yep.
Great. So my name is Jennifer Maisel. I'm an attorney in Washington, D.C. at the law firm Rothwell Figg. We specialize in intellectual property as well as privacy and data security, which has been at the forefront of the news, and it's changing every day. My background is in information science, and prior to becoming an attorney, I worked on natural language processing systems and machine learning applications. And I now get to leverage that technical background in my practice as a lawyer. A lot of my work as a lawyer is litigation in federal court, as well as advising clients behind the scenes regarding their privacy practices and data security, concerning just the vast amounts of information that we're generating every day, particularly personal information.
Okay. And Marty?
Thank you, Adam. As the other panelists said, I'm very happy to be here and participate in this session. I'm a technology lawyer, also a partner of Jen's with the Rothwell Figg law firm. We're based in Washington, D.C. Before I went to law school, I studied computer science. I had a focus back in the 80s on what artificial intelligence was back then. I worked as a software engineer for a number of years and then decided to go to law school. It's been very exciting. You know, I've been practicing about 30 years, and the way that the law relating to software has sort of evolved over the years. It's been an exciting time throughout to practice in those areas. I primarily focus on intellectual property, transactions, and privacy and data protection and cybersecurity. My practice is pretty balanced. About half of it is litigation related matters, and the other half is really dealing with getting patent protection and other forms of protection for my clients' technology, as well as just general counseling and transactional matters. So again, I'm very happy to be here and talk about what we think is a very exciting subject.
Okay, so why don't we get started with the presentations? I think Marty and Jennifer, you're going to do yours jointly. I think for our audience, if you have any questions, please put them in the Q&A box. I think I will be able to read them out if they're appropriate during the presentation. We're also going to save some time at the very end for a moderated panel discussion. So I think with that, Marty, take it away, please.
Okay, thanks, Adam. So our presentation is going to focus on the legal and regulatory framework. We're going to go high level and then provide some specifics about what's happening relating to IoT and AI-enabled technologies. So we've divided the presentation into three parts. The first part is we're just going to try and set the stage a bit by defining, the IoT and AI-enabled technology and the use cases that we think need to be considered and that give rise to the issues and the risks from a legal and regulatory standpoint. In the second part of the session, we're going to run through some of the legal and regulatory frameworks surrounding IoT and AI-enabled technologies. We don't have time to get into the real details, but we'll touch on the data protection laws, GDPR, CCPA, and some specific laws that are in place now relating to IoT technology. And then finally, we're going to finish with some discussion of best practices and some steps towards building a compliance program and a framework for risk management to deal with the legal and regulatory issues we're going to talk about. So you go to the next slide. So what's the driver for the increased focus on IoT from a legal regulatory standpoint? It seems that the reasons are kind of self-evident. The massive growth in the number of IoT devices. You can bring up the points there, Jen. Yeah, I see them. IoT devices that are deployed, that are in use. The sort of now confluence of IoT and AI-enabled technologies are giving rise to new and complex challenges from both a legal and a regulatory standpoint. These devices are dealing with vast amounts of data. A substantial part of that data can include personal information, which we're going to talk about. And that information, of course, collected, transmitted, stored, and processed in various ways. And that creates challenges and risks from the standpoint of security, privacy, and data protection. And all of this is leading to the regulators and policymakers, and of course, also the public taking notice of IoT and AI-enabled technologies. So if you go to the next slide. So we're all aware of the high-profile data breaches that have occurred over the last several years. There's been a rise in the number, and I was kind of surprised when I looked at there's a website here that provides almost on a daily basis an update of data breaches, and I was kind of surprised that we sort of hear about the very large-scale data breaches. What we don't hear about is what you see in a lot of the smaller bubbles there. And of course, it doesn't matter what the volume is. If your personal information is part of the breach, you've got a concern and you've got an issue. So all of this is giving rise to an increasing lack of trust with respect to personal information and how it's being used and processed. When you factor AI into it, you've got concerns regarding algorithmic bias and issues regarding transparency and explainability. And then again, all of this is driving an increased focus from a legal and regulatory standpoint. So now I'm going to turn it over to Jen.
And with that, I'll just briefly touch on some use cases to help frame our discussion and the regulatory and legal landscape. Starting with the Internet of Things, the use cases, we're talking about interconnected sensors, actuators, sometimes with intelligent decision making. In our chart there, we have some examples. For example, I'm wearing a smartwatch today. And there are tons of wearable devices out there that are tracking all sorts of information about ourselves. We have smart home devices, designed to make our homes run more efficiently or more conveniently. Smart manufacturing logistics. If you think about the factory setting and all the connected technology there to improve efficiency and safety and all sorts of great applications, as well as smart cities. Using technology to drive decisions about city design, safety, lighting infrastructure, lots of applications there. And within IoT, we can think about it from the device level. So the actual devices that we have and the sensors, the management of those devices, the connections and networking between them, as well as the security. So we have this whole ecosystem of Internet of Things devices out there. And then with artificial intelligence, it's quickly transforming a lot of areas of life. In the legal practice, we've seen the rise of AI technology used to help automate some of the more tedious and mundane tasks. I've heard AI being referred to as the next industrial revolution. So there's been a lot of attention and focus on AI. We have some applications up on here. We have facial and voice recognition. We have autonomous self-driving vehicles, smart cars, automated drones. On the internet, we have chatbots and AI-enabled customer assistants. I'm sure many of you have interacted with them already, whether you know it or not, as well as AI-enabled robotics and machine learning. And we have a couple different buckets of AI technology up on the screen. Machine learning, which is the dominant technique used today. And kind of within machine learning, we have the subset of deep learning and neural networks, which uses these data structures to draw all sorts of inferences from data. And some applications like natural language processing, which I mentioned earlier, data mining and big data, computer vision, as well as expert systems, smart systems designed to focus on very narrow tasks, whether it's diagnosing a new medical condition or something else, sometimes at greater accuracy than humans in some of the specific examples. So with that, turn it to Marty to talk about the legal and regulatory framework.
Sure, thanks, Jen. So with that, for context, let's discuss the legal and regulatory framework surrounding these technologies. And we're going to start kind of high level, look at the US, EU, and Japan as exemplary, and then drill down into some of the more specific laws and legislation relating to IoT and AI. So in terms of the US, if you can go to the next slide. In terms of the US, and I'll talk about the framework in the US and what we've got, because we don't have a federal privacy act at the moment. In terms of IoT devices and privacy considerations, the FTC, the Federal Trade Commission, has been focusing on these issues, data privacy and protection, with respect to IoT devices and actually targeting IoT technology fairly significantly over the last 5, 6, 7 years, and it's been somewhat aggressive in launching investigations and enforcement proceedings. Some of the specific, we're not going to, in the interest of time, be able to get into the details of cases, but there have been a number of cases dealing with IoT devices in terms of like secure cameras or allegedly secure cameras. There's the TrendNet case, Asus Tech case, Vizio dealing with smart TVs. So it's been a target, and just to mention that most of these cases will get, the investigations get launched, but then usually the proceeding is settled with, in some cases, the company paying some kind of penalty, but more importantly, agreeing to resolve the security issues that gave rise to the investigation, and usually agreeing to some kind of periodic audit, if you will, over a fairly lengthy period of time. In terms of, because I mentioned we have no federal legislation associated with privacy, in terms of from a comprehensive standpoint, we have a lot of states that are taking matters into their own hands. We'll talk about that. And specifically, we have some privacy and data protection legislation around IoT devices. There are various US government agencies like NIST, for example, DHS, FTC, and so on, that are issuing guidelines, trying to come up with standards. There are industry groups as well that are issuing guidelines and recommendations for best practices associated with generally privacy and data protection, and also more specifically relating to IoT devices. There are companies in the industry that are agreeing to comply with guidelines and recommendations in terms of trying to self-regulate. And then there are some specific acts that are up being discussed. Some have been enacted relating to the Internet of Things issues and devices and technology. And I think we can expect to see more activity around that over the next several years. In terms of the EU and Japan, it's somewhat similar with one big exception, which is that, for example, in the EU, they have a comprehensive privacy act that applies to the EU, and that is the GDPR, which I'm sure have all heard about. And then there are some specific other regulations that are complementary to the GDPR. For example, the e-privacy regulation that deals with electronic communications. And then some of the governments within the EU have also issued proposed codes of practice and guidelines around consumer IoT products and associated services. And just like in the US, there are companies that agree to self-regulate and pledge to comply with codes of conduct. In Japan, there's also a countrywide comprehensive privacy law, and there are also some specific legislation and acts that are put into place dealing with IoT. Jen's going to talk about AI. One thing I wanted to mention, which I think is interesting in Japan, a couple of years ago, before the Olympics were supposed to happen in 2020, the National Institute of Information and Communications Technology in Japan began a program of essentially trying to test IoT devices that were deployed. They didn't provide notice to the individuals whose devices were being tested, but essentially they were looking for, usernames and passwords that were shipped with the device that hadn't been changed, and to try and sort of identify the vulnerabilities that would end up likely being a target during the Olympics. So I don't know the status of that program at this point, but I thought that was kind of interesting, and kind of rise to what has caused a lot of the issues and concerns here in the United States and elsewhere, that a lot of IoT devices, at least at one point, were shipped with username and password, and there was no requirement to cause the consumer to change it. And we'll see that that's the subject of some legislation as well in the U.S. now.
Thanks, Marty. So with that, I'll shift over to the AI landscape. I would say generally, the theme here is AI technology. While a lot of the concepts are old, Marty and others have been working on this for decades, but I think the commercial applications are new due to a variety of factors. And, we're in a new stage, and there are a lot of jurisdictions, watching AI closely, seeing what develops. At the federal level in the US, we had the 2019 executive order launching the American Artificial Intelligence Initiative. And following on that, earlier this year, we have draft guidance from OPM for regulations of AI applications. And they have 10 binding AI principles that the federal government should follow when regulating AI. And several agencies have issued guidelines and recommendations. For example, the Department of Defense has issued ethical principles around principles of responsible, equitable, traceable, reliable, and governable AI. And there has been some activity from the national security front. For example, in the Export Control Reform Act, earlier this year, there was some interest, and there is a narrow ban targeting AI software that specifically utilizes neural networks along with graphical user interfaces to discover points of interest in geospatial industry and images. So those types of applications are subject to greater scrutiny when it comes to export. States as well have adopted certain narrow bans on AI applications. For example, in the news, you may have seen bans on facial recognition software in certain jurisdictions, especially when that software is used by law enforcement. Certain jurisdictions, such as Illinois, has focused on the use of AI in hiring practices, looking at video footage of interviewees and using that to automatically infer things about a potential candidate. So they're regulating that and requiring express consent. And for example, there's also California's bolstering online transparency law, which is one of my favorites. It's a transparency issue about AI-enabled chatbots. So if you're in California and you're interacting with a chatbot that has some automated technology in it, and that chatbot's being used to advertise or engage in some kind of election promotion, that chatbot has to reveal that it is a chatbot.
Yeah,
So
Jennifer, we had a question that came in that may be relevant. Would you mind if I read the question?
Please go ahead.
Okay, it's from Robert Stamp, and it says, given that AI will be used in applications that impact public safety, such as autonomous cars, how do engineering licensure laws touch on AI?
Yeah, that's a good question. So maybe starting first with autonomous vehicles, there have been some regulatory sandboxes. Nevada was one of the first jurisdictions way back in 2011 to expressly say, we're going to allow you to test new autonomous vehicle technology and set forth requirements for how to register those tests and, to the government and engage with the government in making sure that those tests are reliable. We've seen a few similar sandboxes out there, but for the most part, if, I hate to say it, but if it's not restricted, companies out there are, experimenting all the time. You see these new products roll out. But I think as a practical matter, especially from an engineering perspective, if you're working in an application that impacts health and safety, a good idea to check, who you need to register with, if anyone. Marty, I don't know if you have any additional comments there.
No, that's excellent.
Yeah, and then picking back off of that, just again in the U.S. high-level regulatory landscape, we have industry self-regulating on AI. Several high-profile groups have set forth AI ethical principles and commitments to ways that they're going to engineer and develop AI technology. And from the privacy perspective, there's this balance in using training data to make better and more useful applications along with privacy considerations, especially when that data concerns personal information. And then just briefly from a global perspective, as Marty mentioned, Europe has the GDPR, and it has this really interesting provision in it about the right to object to automated decision-making. And it has transparency requirements about when an automated decision is being made concerning a substantive right, for example, denial or approval of a loan or other financial service, and the right to object and understand how those decisions are being made. We don't quite have that in the US, but it's something that people have raised and considered. There's the high-level expert group on artificial intelligence, again, releasing ethics guidelines. And in Japan, the G20 Ministerial Statement on Trade and Digital Economy, Social Principles of Human-Centric AI, and the contract guidance of utilization of AI and data. So again, a lot of consolidation where we're looking at AI and thinking about ways to deploy it, but still a very light regulatory touch. With that, I'll turn this back to Marty.
Okay. Thanks, Jen. So with that sort of as context and a high-level overview of where we are on the legal and regulatory landscape, let's focus on the specific risk areas around IoT and AI-enabled technologies. And we've divided it into two categories, the first being privacy and data protection, and the other being intellectual property and contractual rights. In terms of privacy and data protection, to start off providing a little bit of context here, when we think about privacy, as a high-level concept, we're talking about the right to be let alone. But what we're talking about really and focused on with IoT is information privacy and the appropriate use of personal information. In particular, the individual's right to determine how that personal information is used. And the next slide will give a little bit more color around what we mean by personally identifiable information, PII. When we talk about an individual's right, what we're really talking about controlling is how that individual's PII is collected, used, processed, stored, disclosed, whether it's going to be sold, and is it going to be retained? How long is it going to be retained? And if you wanted to make a request to delete it, will it be deleted? And we have concepts that are now built into many of the privacy and data protection laws that provide or require notice, that require a choice be given to the consumer and consent, and provide for the consumer to have access to the data that's being collected, stored, and so on. And again, part of the focus of this is to limit the information from becoming publicly available. When we say PII, let's go to slide 17. When we say PII, personally identifiable information, there are some pretty broad definitions that are kind of throughout the privacy laws, both in the US and abroad. But really what we're talking about is information which can be used to distinguish or trace an individual's identity. Things like, for example, a name, a social security number, email address, biometric records, and so on. The GDPR has a sort of put the finer point, I will say, on the definition and includes other information such as location data, for example, an online identifier, physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. And when we also think about PII, we think about different types of information that each individually may not identify the person, but combination may identify the person. And so all this falls in this broad bucket of what's defined as personally identifiable information. If we can go to the next slide, there are subsets of personal information, particularly what we would refer to as sensitive personal information that under the applicable laws typically gets additional privacy and security limitations applied to it. And we're talking about things like financial information, social security number, tax ID, and so on, genetic data and biometric data. And, you know, one of the things that we need to think about is things like driver's license numbers and passport numbers. If they're hacked and taken, you can get a new one. When it comes to things like genetic data and biometric data, you're pretty much out of luck. So we have to really think about providing very much heightened security and data protection limitations around that kind of data. The other two categories, non-personal information. So how do you take PII and take it out of the restrictions associated with how you have to handle it? You anonymize it or aggregate the data, and then it becomes non-personal. There's a lot of, I guess I'll say, discussion about whether anonymizing or aggregating and the techniques for doing that are really work well in terms of trying to make the information non-personal. And then there's a sort of area in between pseudonymized data where the data, the personal information is actually segregated from the identification of the individual, and the individual is associated with a token. Again, there's a lot of discussion about whether this really is enough. So in terms of the sort of global landscape regarding privacy and data protection laws, as I mentioned, the first category is really comprehensive laws, and we have that, for example, in the EU with the GDPR. Brazil, India, and Japan also have comprehensive laws that apply across the country. We don't have that in the United States. We have may at some point have a federal privacy law. We currently don't. We have essentially a patchwork type system that has different federal agencies that regulate privacy, the FTC that we mentioned before. We've listed some other federal agencies that are active in terms of the privacy arena. And then we have states, and we're going to get into the individual states and how they are sort of taking matters into their own hands to deal with privacy issues, as well as including regulating IoT devices. The other two categories of privacy law that we see, one is co-regulatory, where there's not a comprehensive law, but a federal law that is very narrow, but then self-regulation codes or conducts that companies, organizations, and individuals within the country can just agree to abide by. And then we have some countries that have no privacy laws in place. So if we move on, let's focus on first the United States and what we've got. The privacy law on a state level that most may be familiar with is the California Consumer Privacy Act, CCPA. It got a lot of notoriety in press. It sort of came on the heels of the GDPR. It's got a lot of comprehensive coverage and similarity to the GDPR with some areas that are a little bit different. It was signed in 2018 and had a horizon before it took effect in January 2020, which it has. And the act is, we've sort of experienced it, if you will, with our clients, trying to study the rules and regulations and figure out what kind of mechanisms they need to put in place to comply. Enforcement has now begun. So we're just going to see a lot of evolution, I think, in terms of how the CCPA plays out. And hopefully we'll get, some additional guidance as to how to advise our clients on these issues. There are 2 other states that have what, fall into the category of comprehensive privacy laws. Maine, which took effect in July 2020, the Act to Protect Privacy of Online Consumer Information, and Nevada, which took effect in October of 2019. We have a link to a comparison study that the IAPP did that deals with the various aspects of these acts. And like I said, there's 3 states that have it enacted. We'll see in a couple slides, there's a map that has a whole bunch of other states that are also have pending legislation under consideration. But this comparison is really useful, and it talks about, consumer rights on the one hand and business obligations on the other. And, if your company is either doing business in these states or collecting personal information on residents of these states, need to pay attention to these acts.
So Marty, we also have a question that sort of looks at all of what's happening with the states, but it's from Len House, and he asked the following. The Cyberspace Solarium Commission just released a report that calls for federal legislation for IoT security. What is your take on that recommendation?
That's a great question and a great point. And I guess from my standpoint, I'm all in favor of federal legislation dealing with these issues. And I partly say that because, sure, my business, I get a lot more business if every state has a different law relating to a particular technology area or legal issue. But the fact is, it's incredibly hard to navigate and advise clients about how to be in compliance and lower their risk. If we have a federal law that deals with, for example, IoT technology and creates, a regime that has standards, that is clear, that would be great. I would be absolutely in favor of that, and I'd actually be in favor of, having a federal comprehensive privacy law that would bring some clarity and consistency to this area across the country. And I haven't checked recently on the activity on the Hill associated with that, but it's certainly something that is on everyone's radar. So I hope that answers the question, and I hope Jen is on board with me, but if she's not, she should let you all know.
Yeah, no, I echo those sentiments completely. And I would just add that the Federal Trade Commission, they do have a lot of resources on their website concerning security of IoT, as well as the enforcement actions that Marty talked about earlier. I'd say that's maybe the closest we currently have to some federal, guidance and oversight over security of IoT. But I think maybe a bill would simplify that greatly.
So there is a sort of a counter question, I think, from Anil Kripalani, and it says, have any rules been relaxed or need to be relaxed to, for example, allow for COVID tracing?
Yeah, that's also a great point. There was a bill in the House and a bill in the Senate associated with providing exceptions regarding for example, contact tracing and the information that would be collected and used and processed and so on. And when I last checked, both of those bills were just sort of sitting and nothing was happening. They weren't making any progress. So I think the answer is that there has been no relaxation at a federal level in connection with that. I might say unsurprising, but I won't say that. All right, so we have a couple of slides that deal with the CCPA, just to give you all a flavor of how broad the coverage is. Yes, it's the California Consumer Privacy Act, but it's pretty broad in terms of what it covers, the businesses that it covers. So in terms of the definition for covered businesses in the CCPA, any for-profit entity that, one, does business in California, two, collects personal information of California residents, determines the purpose and means of processing that information, and meets one or more of the following criteria. So here's where you have a little bit of a dividing line in terms of which businesses are covered and which are not. Generating 25 million in annual revenue, holding the personal data of 50,000 people, households, or devices, or makes at least half the revenue from the sale of PI, personal information. So there are lots and lots and lots and lots of companies that this would apply to, I believe, and it's pretty broad. And then as far as the individuals that are covered by it, it's really any consumer that's in California, a resident of California, domiciled there, or if you're a resident of California and domiciled outside the state, it would apply to you. And then the personal information definition that the CCPA applies to is also very broad, and interestingly includes personal identifiers like online IP addresses and the internet or other electronic network activity information. So point is, it's very broad. The map, which I mentioned, which is the next slide, is showing that we have the 3 states, California, Nevada, and Maine, that have comprehensive state privacy laws. Then you can see that there's a number of other states that either have introduced legislation, have passed legislation, and I think, notwithstanding a federal privacy law, I think we're going to see other states that are going to start working on legislation. And again, the issue really from a practical standpoint is they're not all consistent. They have different definitions and different requirements. And if you're a company that's doing business throughout the country, which, a very large percentage of companies are, you've got a real, difficult time trying to navigate through and make sure you're in compliance. In terms of technology-specific laws and regulations, I mentioned there are some states that have specific regulations related to IoT and connected devices. California, security of connected devices, which was enacted along with the CCPA. Oregon has an act, and then there are a number of other states that are looking at similar legislation: Illinois, Kentucky, Maryland, Mass, New York, Rhode Island, Vermont, and Virginia. So if you're operating in the IoT space, you're going to have to start looking at these bills and what the pending legislation is, and try and act accordingly. We also included on here ISPs because there's a number of states that have enacted specific laws directed to ISPs. California, Maine, Minnesota, and Nevada have already enacted those laws, and there are 14 other states in DC that have pending legislation. And they're trying to, restrict how ISPs collect and use and disclose, the information. And it includes things like web browsing, history, app usage, geolocation data, and so on. We have a couple of slides just to give you a flavor of the IoT, security of connected devices in California. It's broad in terms of what it applies to. So for the definition of manufacturers, it's basically the manufacturer, the person who manufactures or contracts with another person to manufacture on the person's behalf connected devices that are sold or offered for sale in California. So very broad. And the definition of connected devices is also very broad, as you can see. And then there's a hasn't been a lot of information available on how this law is going to be applied or interpreted, but there are definitions. The requirement is really that those devices have reasonable security features. And there's some criteria around what those features are. But in terms of how you would comply, if a connected device is equipped with the means for authentication outside a local area network, it shall be deemed a reasonable security feature under that previous section if either of the following requirements are met. So one, as I talked about before, the pre-programmed password is unique to each device manufactured, or the device contains a security feature that requires a user to generate a new means of authentication before access is granted to the device for the first time. So you can comply, but of course you have to be aware of this and make sure that the IoT device is in compliance. And there may be some gray areas. As I said, we haven't had a lot of guidance yet, but I'm sure it's coming. Oregon, just that I mentioned, also has a similar act, a little bit of a narrower definition. And with that, I'm going to turn it over to Jen, who's going to focus on some of the technology-specific laws relating to AI.
Bertie, I'll just briefly again mention that, there are no states with specific legislation directed to AI-enabled technologies, and there's a lot of, let's look at this technology and see how it's being developed. There are AI task force in a variety of jurisdictions, as well as at a federal level, to examine these technologies and recommend how they should be regulated and if they should be regulated. And there are a lot of different sources of privacy law. If we think, for example, at the constitutional level, the Fourth and Fifth Amendment, we had some case law on privacy concerning GPs. I have the case site up there, the Carpenter case, and whether there's a reasonable expectation of privacy in certain geolocation data. As I mentioned earlier, there are a couple narrow statutes targeted towards certain AI applications, whether it's facial recognition technology, AI in hiring, these chatbots on the internet, as well as self-driving vehicles. And, on remote tracking and surveillance, whether you have one-party consent or two-party consent laws with regards to recording conversation, legislation directed to drones and video surveillance. And just in the interest of time, we have a couple of slides here, which will be available for you as a resource, talking a little bit about some of the privacy considerations on a global level, as well as the European Union's GDPR and the e-privacy regulation. But with that, I'm going to jump and switch gears a little bit to talk about intellectual property and contractual rights. And when we're thinking about IoT and AI-enabled devices, I think at the forefront of people's minds is the data and how do we protect that data. In the US, our copyright law protects some aspects of data, but not all. There's limited protection only over creative elements added to a data set. For example, if you have a unique arrangement of data, or perhaps you're tagging it and augmenting it, used for a training model, there is some support for having copyright protection over data sets like that. And in Europe, they have a slightly different approach. They have a sui generis database right. It's a limited copyright protection over pure data sets. And late last year, the United States Patent and Trademark Office was soliciting comments on whether we in the US need a new type of IP right for data sets, particularly in the view of artificial intelligence and machine learning applications. So no movement there yet, but a lot of discussion about how do we protect the data. That said, as a stopgap, those companies rely on contracts when it comes to protecting proprietary data sets. You'll see contractual obligations restricting access and use of the data set, whether it's an end user license agreement or terms of service on a website or a purchase agreement. There are going to be provisions most likely addressing the usage of data from that site. And when we think about issues like web scraping, if an entity goes to a website and collects data from that website, certain companies are experimenting with controls over accessing that data, requiring CAPTCHAs and things like that to prevent people from doing that. On the flip side, there's a lot of open access data sets out there. The United States releases a lot of data at data.gov. And in contrast to proprietary data sets, there's typically limited or no restrictions on access and use of the data. And we have a little checklist here for you when you're thinking about data scraping issues, particularly in the context of machine learning. Just a little checklist to go through to make sure you have the rights to actually collect and use that data. And that I'll just touch briefly on additional types of IP protection for IoT and AI. There's obviously patent protection, and we've seen a tremendous growth in patent filings for both IoT and AI-related inventions. Here, there's always the balance between patent protection and trade secret protection. If you file a patent, it means you have to publicly disclose perhaps a secret underlying algorithm or data structure or new technique in exchange for a limited monopoly and exclusivity period. And most interestingly, earlier this year at the Patent Office, in response to a patent applicant submitting an application that they contended was invented by their convolutional neural network, the PTO released guidance saying that an AI entity, a piece of software, cannot be named as an inventor. An inventor has to be human. It's not a surprising result, but and there are a lot of ways that a human can kind of insert themselves into that loop to claim conception and ownership of an invention. But it's an interesting thought experiment. And one benefit of trade secret protection is that it has a potentially longer life than patent protection, but only so long as you keep that technology a secret. And again, here we have a little checklist thinking about restrictions on use of IoT and AI software and technology. Is there an issued patent covering the technology, license terms that may cover it? And particularly when we think about acquiring companies or acquiring data sets and things like that for technology, there should be a due diligence review where you evaluate security concerns, source code issues, testing stability, and support. And with that, I'll turn it over to Marty. Oh, Marty, you're on mute.
Great, thank you. Didn't want my dogs to intrude on our session. With all of that as kind of the backdrop, from a practical standpoint, how does the organization practice best practices in this arena, building a compliance program and a framework for risk management? We're not going to have time to get into all of the details, but just a couple of points. There are, key considerations to how you demonstrate that the organization is practicing reasonable privacy and data protection measures. We've listed here what are the core data protection principles that need to be considered in evaluating and then designing and implementing a data privacy and protection best practices program. These are all the considerations. I'm not going to go into the details of each, but if we go to the next slide, from a practical standpoint, how do you develop that program? What steps do you need to take to establish that framework and for risk management and best practices? And so there are some, what we find defined steps in order to put a program in place. Number one, in a lot of clients that we work with, just establishing a governance structure that's going to be responsible for data privacy issues and data protection. And it oftentimes touches many areas within the organization, and getting C-suite executives to be participants in the group that deal with these issues is critically important, actually, to get buy-in from the organization. The second step, personal data inventory. So creating a data map. A lot of clients we find, they don't necessarily even know all the different data that is being collected and how it's being used and where it's being transferred and what third parties are touching it and so on. So creating a data map.
So Marty, we
Yes.
actually have a question that sort of touches on this in an interesting way. It's again from Lynn House, and it says, the laws rarely cover the transfer of ownership over the life cycle of a device. What happens when I sell my house full of IoT devices to a new owner? Is the data cleared, and how can I assign a new owner securely?
Yeah, I have to say, I just sold my house about a month and a half ago in DC, and I was there for 10 years, and I put in every kind of, as a technology guy, every kind of IoT and, smart thermostat. And I actually thought about this whole process. And I think it's a really, really, really difficult challenge. I tried to wipe, everything out that I could in terms of my personal information, like passwords and things like that. I worked with service provider, like ADT and other companies that had, I guess I won't say control over my systems, but that I was controlling my systems through. And,
Or you had the illusion of controlling.
yeah, right. Right. So it's a great point. I mean, would there be liability associated with it? I don't know. The person that would be harmed would be you. So contributory negligence. It's a great question. I wish there was a piece of software or some other type of application that could be used to wipe and scrub all of the devices, IoT type devices in a home setting of all that information. But
It should be a requirement ab initio, maybe. Anyway, let me do a following. I'm going to let you go. If we could finish up so we give our other speakers a chance. Okay.
Sure.
Terrific.
we're just about finished. So the other part of this compliance program and building the program beyond the data map, most of the applicable data privacy laws require that there be notices given to consumers about what you're doing with their information. So you need an external policy and notice, and also an internal policy of how you're going to deal with personal information and protected data. Individual rights and consumer preference management system. There's software platforms that can help you deal with this, but the individual you're collecting the information on, did they opt in? Did they opt out? Can you sell their data? Can you not sell their data? Third parties is a huge issue that we see. There are clients that have all kinds of personal information. They may have a great internal policy and internal program, but a lot of that data is being shared with third parties and vendors that they're dealing with. Do they have the right contractual provisions in place to make sure that they're complying with the applicable privacy laws? Internal training and awareness. If there's a breach, you have to have the operating procedures that you're going to deal with to isolate the breach, determine what the cause was, remediate it, and then come back online. And then continuous compliance and monitoring is required by most of the applicable privacy laws. So with that, I'm going to turn it back over to Jen, who's going to close this out.
Thanks, Marty. Just a few brief points to raise on close. And thinking about the house question, I think the reality is a lot of these issues are going to play out by contracts. And I would say, what does the sale agreement say? And I haven't seen this yet, but is there a rapid warranty about the data associated with the house? Has it been secure or reasonable security practices maintained?
So Jennifer, I think you just started a new startup that somebody says it's called Home Data Wipe.
All right.
I think I would just,
From Anil Kripalani, okay? So.
I don't know if you can hear me, but I would add an interesting comment here. Someone raised the new proposed bill, IoT Cybersecurity Improvement Act from the Cyber Solarium Commission report. If you look at the proposed bill on section 2C, I think 4, as one of the exceptions, they're actually talking about are we selling by an individual consumer? So isn't that interesting? Relates to your to this discussion.
Yeah, that's fantastic. Yeah. So just a couple points to close this out. You know, we've focused a lot on the statutes and just, you know, the requirements in the statute, but as a practical matter, there are a lot of open issues. You know, how do we define harm and liability, for example, from a product defect perspective? What if you have an AI-enabled technology that's trained one way in the lab, and then it evolves in a new way once you let it out into the world? What's our standard of care? How do we define reasonable? If it's a machine, is there, you know, a reasonable, you know, is there an ordinary machine standard that we need to use? Do we need a human element or interface for their systems? If we have an autonomous system, how do we assign liability when something goes wrong? Who or what is responsible? Is it the device manufacturer, the software provider, the person who sold the device, the user? You know, there are lots of entities involved. How do we make sure that this technology is ethical, legal, and comports with our society standards? And as Marty touched on earlier, especially with AI, there's a lot of interest right now on having non-biased, explainable, and transparent AI, the right to explain result. And with that, we'll conclude our presentation. Really appreciate the opportunity to speak today.
Yes, thank you.
Yeah. So Jennifer and Marty, thank you. I think we'll come back to you during the discussion. But in the meantime, Anahit and Amit, if you could launch into your presentation.
Absolutely, we can. And hopefully everybody can hear us and they can hear us well.
I can hear you.
Yeah, we can hear you quite well.
Great. So, and the slides are up? Yes?
Yes.
Wonderful. Well, thank you, everybody. Again, we are really excited to be here. We're going to be really interacting and touching upon some of the threads that you already heard about, I believe, in the prior presentation. So it's really exciting to see how all the pieces are getting connected. But we are also going to be really focused on, looking into more deeply those security elements and baselines and drilling down to some of these best practices and standards that our fellow panelists discussed. I'm excited to be here today with you. Again, my name is Amit Elazari. I'm from the policy side at Intel, so I do government relations. We sit within the legal department, but we look at future regulation. And I'm going to be sharing with you a little bit about my own background and kind of why I kind of stumble upon this area of law and technology and security and what I am passionate about. I'm joined today with Anahit. So what you have here is a collaboration between a security researcher and an engineer and a kind of a policy wonk or lawyer, whatever you want to call it. And these are the types of collaborations we love to see in this area. A little bit about kind of, my own background. I think you heard today, the law is interacting with technology. And, that interaction is just growing and growing. You heard an overview of so many concepts that are being considered by policymakers. By now, CCPA, GDPR, FTC, all these acronyms. I'm sure these are not the first times you're hearing about this kind of concepts. And I think, the real kind of takeaway and what we're going to be focusing on is how that is working together with technology. So what are the opportunities to use technologies to kind of support and enhance some of these conversations, and how, we are monitoring and we are engaging in the sphere as technology and policy are kind of moving together, and really focusing on IoT, because as you've seen, it's one of what we call like the hot spots. It's one of the most evolving area of proposed regulations, whether it's coming from privacy, machine learning, AI, the evolving landscape of IP you heard about, contractual, or security. A little bit about my own passion. I do feel like law and technology is one of the most fascinating areas of the law to work on. It is so intertwined, so kind of conceptually related that we really cannot separate it anymore. And I feel like as we are engaging in this kind of sphere, what I at least try to do is work very closely with our engineers, work very closely with people like Amit, work with security researchers and hackers, and then basically engage in those kind of interdisciplinary conversation like you're gonna hear today as we tackle the challenges. Specifically, you heard a little bit already about this kind of one of the challenges I think we have in this sphere, which is laws typically move slower than technology. So innovation, technology is constantly developing, and yet laws are generally harder to amend. It takes time to develop them. Concepts in laws are often what we call principle-based, like this notion of reasonable security that you heard about, like the notion of reasonableness in general. And laws are often design neutral. This means that you generally will not expect to see a certain technology or design, or even a certain very specific technical term in a law. And the understanding there is that as the technology evolves, the policy landscape and the laws, because they can never keep up with technology, they're always, kind of trailing behind, they need to accommodate the changing circumstances and also not hinder innovation by by baking into legislation a specific technical concept. So if we think about this kind of landscape, one of the prominent examples, which also is very connected to our discussion for today, is the Computer Fraud and Abuse Act. Now, this is the main anti-hacking law, U.S. federal kind of regime in the United States. Is very relevant to security research, for example, and this is a law from '86, before the internet as we know it. And it was, according to this media article and a lot of kind of the conversation out there, it was actually inspired by a Hollywood movie, War Games. Only now and we have experienced a lot of discussions around this law and what it means to have, what it is exceeding authorization. How can you basically bound the authorizations, whether it's via contracts or via technical measures, and some of that was discussed in the prior presentations. Only now the Supreme Court is taking one of the kind of key, I would say first at the Supreme Court level, cases to kind of really drill down on this issue of authorization, and it's a criminal case. All of that to suggest is, as technology evolves, we still have laws and concepts that are in the books, and we are trying to apply them and adopt them as technology moves along. Even though they're from decades ago. So very interesting case to track, by the way. But the broader kind of takeaway is this kind of interaction between law and technology. Brings me to my own personal background. I worked a lot, I did my doctoral degree in UC Berkeley. I worked a lot on this issue of anti-hacking laws before I joined Intel. I was very passionate about connecting ethical, friendly hackers, if you will, with companies and basically building bridges to allow security researchers to report vulnerabilities to companies. And I worked a lot on creating frameworks like one, contractual regimes. This is Disclose.io, my prior work, and safe harbors in bug bounty contracts and vulnerability disclosure program. And we're going to talk a little bit about that particular trend, this idea of collaborating with the security research ecosystem, which is really connected to the policy conversation on IoT. And as you can see, we heard a little bit from the prior speakers. We have specific agencies in the United States and all over the world, for example, the Department of Justice, issuing best practices, recommendations, just documentation around considerations, around various concepts in security that interact with the IoT ecosystem. And this is, for example, a framework on this idea of having a vulnerability disclosure program. We're going to talk about it. So, if you ask me about my personal kind of passion, and then, a lot of the work that we do at Intel is basically fostering that collaboration, because it's clear that that's some of what we are going to need to tackle this ecosystem. We are going to talk with you today about a lot of the kind of the policy evolving landscape, but there are, specific examples on how, for example, companies use bug bounties, and we have a bug bounty at Intel. to collaborate with the ecosystem. And this is an interesting example. I think the EULA was raised before the end user license agreement and this whole kind of contractual lens. This is something I worked with Tesla before I joined Intel to draft their bug bounty, add a safe harbor protection from anti-hacking laws. But in addition to that, one of the things they've done, they've also inserted a clause saying that if you test your Tesla as a good faith security researchers and you're already registered under their bug bounty and you happen to have a Tesla and you want to participate in a bug bounty, and in the course of your security research and testing something goes wrong, they specifically void the warranty limitations in the EULA for that purpose, and they would fix it for free. Now, isn't that interesting? I encourage you to check out that kind of language. It's a novelty, I would say, in the embedded systems system. And at Intel, we also have a bug bounty. We invest a lot of time in collaborating with the community, especially the embedded security research community, and we have a language with respect to this issue of interaction with the CFAA. So you heard a little bit about my own background, excited to be here. I'm going to share with you a little bit about the evolving policy kind of landscape together with my collaborator, Anait. But my disclaimer is, although I have a doctoral degree in the law and my background is legal, I'm not in the United States. I am a lawyer, but I'm not your lawyer. I'm going to be talking about my own kind of opinions and my prior work, and this is not legal advice. So you should have expected a little bit of fine print from us. And with that, I want to invite my collaborator to share a little bit more on what is actually triggering this kind of high volume demand or conversations around IoT proposed policies and regulations. Anait, take it away.
Thank you, Amit. Hi, folks. Glad to be here. Very interesting discussions. And as Amit said, I work directly on the product definition side, right? Today, we are talking about IoT security regulation policy. I participate in several IoT policy activities. My perspective is the practical implementation. So being on the receiving side of the regulatory guidelines inside Intel, I spend time understanding and assessing the technical and business implication of this blooming regulatory proposal. And let's first understand what exactly behind this momentum in a policy space, right? So as the previous presenter said, so Internet of Things is blooming. It's blending actually the physical, digital world. It is transforming the way we live and work, right? And if we look at the latest 2020 Gartner hype cycles, IoT and AI and machine learning specifically, right, both are trending at the rise. So we face with a well-known dichotomy. That's what Amit brought up, right? This is the problem of innovation, the speed of innovation and reactive regulatory response, as innovation often undermines the holistic implication of technology growth, right? Specifically, it's quite common that the business motivation of innovation prioritizing the time to market over security or safety, right? On top of the IoT proliferation, industry is confronting emerging AI and ML challenges that in comparison to cybersecurity requires even more foundational research to ensure its trustworthiness. Again, agree with Marty and Jennifer about the AI ML related issues of explainability, safeties, biases, and other problems that industry is exploring. So all these challenges don't only exist in theory. We're already aware of substantial vulnerabilities discovered both for IoT and AI ML workloads. So first, let's look at the threat landscape. What are those concerns? So we are one of the key IoT issues is the expanded attack surface due to its increased number of the endpoints. As we know, the futurescape predicts the billions of devices, trillions of sensors. The large number of IoT devices that's being brought into business triggers the spike of attacks. Another issue is the sophistication and evolving intent. What does it mean? It is clear that the attack target is not limited to the assets of IoT device only. IoT device exposure opens plethora of opportunity across the edge to cloud and exposures of more valuable assets. So let's analyze maybe the genealogy of the IoT attacks. And we will start with the IoT device itself, so IoT threat landscape. So the existence of botnets exploiting vulnerable, often poorly secured or configured IoT devices have been known for a while. So I'm talking about this high profile, the DDoS attacks triggered by IoT botnets such as Mirai, right? It was around 2016. This was the indication of the potential devastating impact that this device can represent. So since then, the volume and sophistication of attack targeting the IoT device have grown sharply and new classes of attack emerge. So device credentials, again, the password problem, misconfiguration, ransomware, right? IoT also entering that ransomware space, physical attacks, sensitive data protection, we talk about, right? All the privacy implications. And so these last two, the data protection and privacy protection, and plus the IP cloning, get even more prominent in the context of the AI and machine learning. In case of the AI privacy exposure, it basically becomes a roadblock for the new innovation, the use cases such as federated learning in the healthcare segment, for example. So let's understand the uniqueness of this IoT space and right, that evolving intent of the attack. So what you see is typical IoT solution that spans edge to cloud. IoT devices control other devices in this system, right? And they themselves have been controlled by these other devices in this edge to cloud ecosystem. This duality exposes enormous challenge for security and adds a new dimension to the system cybersecurity controls. Attack that originates at the edge easily can propagate throughout the entire pipeline, and a single device can jeopardize the entire solution. So one notorious example of this type of scenario is the casino fish tank attack. So let's move to next slide, right? This is the classical attack. So here's the story. So using the trivial vulnerability in the smart thermometer in the fish tank, hackers gained access to the casino network. They retrieved the data about the high paying customers and then extracted that data through the same thermometer sensor to the cloud. As a result, about 10 gigabytes of the data ended up in Finland. This looks like a Hollywood-ready story, perfect for Ocean trilogy sequel. But from our perspective, this just to prove the point that the simple device, in this case it was thermometer, can break down the protected, very high protected casino networks. And just hot off the press, a vulnerability discovered by IBM researcher that was published just a couple of days ago. This is about the flaw in the wireless module that used in devices across a variety of industry. It's a healthcare, automotive, energy, telecommunication. So this attack opens up the far-reaching opportunities for hackers. So smart meters can be wrecked, or the insulin pump could be manipulated to overdose the patient, and it would be possible to clone device or modify the device functionalities. So quite alarming. So with that many devices already deployed and even more on the way, it's important to consider what is uniqueness of the IoT space, right? Especially compared to existing traditional devices, compute devices. So let's first look at the technical and the business side. Right, and there are several factors that contributed to IoT technical and business challenges. So first is the complex ecosystem. There are several entities, players involved in defining the finished end customer usable product. Right. There is a broad diversity of distinct market segment. We just talk about healthcare, industrial, etc. Right, and each of these segments have their own unique business models. IoT usages need to meet stringent power performance form factor requirements. There is another uniqueness in the wide range of the software firmware that covers operating system, hypervisor, bootloaders, and all other the software bill of material that comes with that device itself. Heterogeneity of this tool base, it's another challenge and it's a unique factor. So IoT is a mix of the green and brownfield devices. And on top of it, we have the icing. It's that some IoT devices need to be supported over extended period of time, right? The lifetime of devices much longer than the life of traditional PC, phones, or servers. All these challenges become contributing factors to the vulnerability of IoT devices and introducing the security risk that trigger this industry concern. The concern that needs to be addressed in the policy arena, right? And here I would like ask Amit to share her insight from the regulatory guidelines perspective.
Yeah, thank you so much, Anait. And I think, our audience has already seen a little bit of, how those kind of policy principles come to play in some of the overview we saw before. So, the key issue is this is really a complex and emerging ecosystem. We still have a lot of things that are still developing, right? The technology itself, including the security capabilities and the innovations. Very different business models, right? We have in one kind of segment of the IoT landscape everything from the kind of the cheap dog collar, if you will, to sensitive systems, critical infrastructure, medical devices. So it's a very kind of vertical landscape that has both various business models, various technical, I would say, limitations and technologies at play. And the attack surface, by the way, is also different in those various kind of verticals. All of that to suggest that from a policy principles kind of perspective, we need to take that into account as we are considering, regulations, policies, best practices in this area. So what are kind of the key principles? Risk-based approaches. That's a very dominant, by the way, theme across all security policy issues, not just for IoT, but it's especially important for IoT because the context of where the device is being deployed, right, and the vertical means a lot. So from a security perspective, we want to kind of still consider that kind of risk-based, consider the ecosystem, consider the deployment, consider what the manufacturer can or cannot anticipate with respect to the device. I think that's a big theme we've been seeing. Supporting innovations, we all recognize that we got to make sure that policy is also facilitating future R&D, future innovation, is not hindering innovations, because technology is going to help us solve some of these issues. Interoperability, so that is a really critical theme. As you think about IoT devices, the way they interact with the broader ecosystem, with the OT ecosystem, with the IT ecosystem, and the proliferation of devices that are connected together also with other areas like network, like PC, like edge to cloud. The interoperability is a key concept we want to foster, and that brings us to increased reliance on international, scalable, consensus-driven standards. So, we talked a little bit, our previous presenters, they've shared a little bit of their perspectives on this issue of fragmentation and how it is challenging for global manufacturers to operate in a sphere where we have, fragmented regulation or, localized requirements. Especially if we consider technology, right? The nature of technology is global, the supply chain is global, and the deployment of IoT devices is a global phenomenon. So it's very important to foster international standards and rely on harmonized international standards. And we're going to be very specific today and tell you a little bit about, what are kind of the key baseline standards that are being developed both at ISO, both at ETSI, and again, this work by NIST that is accompanied by some CTA work as well. Design neutrality, I talked about that. That is this kind of idea and concept that we should not bake into a legislation or regulation specific, design requirements or manufacturing requirements or even technical concepts that might become outdated with time. So by way of example, password. Today we have passwords. In the future, we will have a variety of authentication means. Maybe, we are not going to have a lot of user interaction, right? And this is just to give you an example. We want to avoid having a legislation concept that cannot keep up with technology and how technology evolves. Private-public partnerships are going to be, that is going to be absolutely important, having that dialogue between private and industry parties and policymakers as they're considering this landscape. And of course, how IoT is working together with a broader ecosystem, not just in terms of bleeding what we call policy domains like AI, privacy, and others, but also, how the IoT ecosystem is, cloud to edge, kind of impacting the OT environment, the IT environment, and other environments. So let's, a little bit go into the details. There are areas that you already heard about, and I'm not going to go into much detail on, but it's certainly an evolving landscape. And I think what you've seen is it's evolving not just in, various domains from data protection to privacy to machine learning. It's also evolving in terms of the policy vehicles, quote unquote. So we have seen proliferation in both, proposed legislation. That's, these are laws, whether it's in, California, Oregon, federal proposed. We're going to talk a little bit about that globally around the world. But we've also seen a lot of attention, a lot of work going into what we call consensus-driven standards and baseline, I would say, kind of conversations around security of IoT devices. We have also seen sector and specific and domain specific requirements. I'm going to show you a little bit of examples. So this is basically the conversation is not just horizontal, the entire IoT ecosystem, from the dark color to the medical devices, but we have also seen specific efforts and profiles. For example, we know there is a federal profile being proposed by NIST for all IoT devices that are going to be potentially procured by federal agencies. Can we take questions in the end?
Yeah, Adam? So there is a specific question, maybe actually one view graph back. It's from Anil Kripalani, and he said, yesterday we talked about smart cities. Are the public-private partnerships you talked about being worked so that interoperability is designed across a full set of subsystems for smart cities, and therefore the issues of security, et cetera, are automatically built in?
Yeah, I think one of the key prominent conversations we are seeing is the baseline conversation on security capabilities, which is horizontal. It cuts across a lot of sectors, including the smart city. So we're going to provide a little bit more information about that, and if it's okay, we can take additional questions.
And the other question he asked is, what organization is actually leading that?
Okay, so broadly speaking, there are many IoT standards in development. NIST is doing a lot of work on NIST 8259. There is a standard in development, ISO IEC and SC27, and CTA is actually also definitely leading horizontal conversations. They've both done work on the C2 consensus report we're going to talk about, and a specific standard they are now developing. In addition to that, at ETSI, there is a consumer household focused standard we're going to talk about. So we're going to give you a little bit of that information. To really drill down and kind of provide an overview of some of the key issues, I'm really going to focus here on updates. I think you heard the perspectives of, the other panelists that have introduced you to some of the things we have seen in California and Oregon. So we have state laws. You heard about that already. We have some being proposed right now. Already we have seen, by the way, in some of the proposals, different definitions to the point about fragmentation, at least in the state kind of approaches. It is definitely something we are monitoring. We have seen proposed federal bills. So one of the former questions was around the Cyberspace Solarium Commission report. They have recently proposed to expand a previous proposed bill that was focused on IoT for the federal procurement kind of side to all the market legislation on IoT security. In addition to that, and it's interesting to see, by the way, the Cyber Solarium Commission is referencing this document by NIST. We have seen tremendous leadership by NIST working, taking all of industry together to develop a core baseline for IoT security devices. We're going to drill down on the kind of the proposed, I would say, pillars, the 6 key capabilities in that baseline. And I think that is going to be very of particular interest for this audience. It's going to become a little bit more technical. And that effort is actually going international. So basically, there is an ISO IEC being developed at the international level with experts from all over the world kind of discussing what are kind of the baseline security capabilities for all IoT devices. I'm one of the editors of that particular standard, LSC 27, and there is an ETSI specific for the household segment. This is not covering, you know, the specific domain standards we have in this field. One of them, which is very prominent in the industrial sphere, is IEC 62443. All of these standards, by the way, are becoming increasingly more important as the landscape evolves and as we are considering, you know, the policy conversations, right? So there is an interaction between all these things. A bit of updates. You heard a little bit about leadership coming up, you know, around the world in this area. The UK has since took their code of practice that you heard about, and they proposed an actual regulation on consumer smart product. It's no longer just proposed for IoT. By the way, it's now being proposed also for laptops and PC. You see the domain bleed there. This is in consultation. This is not a law yet. This is being considered and then inviting comments. The code of practices and the risk frameworks approach, METI from Japan was mentioned here before. They have since released another framework for risk kind of based approaches to IoT. Very evolving conversation in Europe. You heard a little bit about it from the privacy perspective. From an IoT perspective, we know that, you know, ENISTA is certainly considering certification. This might be one of the priority areas for ENISTA's work, and their forthcoming directive changes. We might see more implications for IoT devices. And I talked about domain-specific requirements. So, for example, the NIST federal profile, which is for the federal government procurement of devices. Finally, I would just briefly highlight the IoT security policy conversation is not one that is happening in isolation. It kind of interacts with other security policy kind of very prominent things we've been seeing. One of them is supply chain transparency. If you haven't heard on the initiative by NTIA called the SBOM, the Software Bill of Materials, this is this idea that you should have a visibility and transparency into the ingredients of the software, and that visibility into the ingredients supports the capabilities like security updates and the like. A very prominent conversation happening of security on many areas, but definitely specifically surfacing up in the context of embedded. It's actually referenced in the NIST as well that we're going to talk about. All of this is also connected to another big thing, which is code and vulnerability disclosure, an area where Intel has a lot of leadership around. We do multi-party coordination with the entire ecosystem to remediate hardware vulnerabilities. And I think, you know, we have seen kind of the conversations around updates being very intertwined with the IoT conversation. And most interestingly, by the way, and I'm going to show you one example, this concept of working with the community, this concept of having a vulnerability disclosure program, a point of contact, a security at email, a policy that sets the expectations, not necessarily paying for the vulnerabilities. That is something we call bug bounties, where you're actually actively incentivizing and paying for vulnerabilities reported by external researchers, but just merely having that point of contact. That big thing we have also seen proposed in IoT, I would say, standards and legislation, certification, and you've heard extensively already the data protection and AI and machine learning kind of bleed. So let's just give you an example. Again, I've talked a lot about the trends. This is the recent, just last month released consultation coming from the UK. They've taken their code of practice. Now they're proposing a legislation. Not anymore just focused on IoT devices. This is from the prior consultation. I just wanted to show you the interaction with this ETSI standard that is being developed. Now they're talking about free core requirements. That is not a big change from the prior approach. But again, this is now being proposed also for PC and laptops. The issue of the default passwords, the issue of the managing of reports. So the vulnerability disclosure program, we talked about that. By the way, the FTC was mentioned before. In 2 cases, at least, I think, the FTC has suggested that together with many other considerations, not having a means to kind of receive the reports of external security researchers and handle them might be considered, again, together with many other considerations, unreasonable security under Section 5 of the FTC Act. Now, isn't that interesting? Requirement number 3, transparency around the security updates. So, you know, this is just to show you how regulators are becoming very specific. They're considering specific requirements. This came from the IoT household kind of arena. Now it's being kind of proposed also to PC, and it interacts with a specific standard, which is this ETSI. We got the previous question about standards that are prominent. I think this is one to watch for. Brings me to the kind of latest and greatest already mentioned on this call. We talked about the Cybersecurity Solarium Commission report recently, and this is also really released this month. Their COVID white paper annex, pursuant to their 80 or so recommendations overall, has also suggested that the IoT Cybersecurity Improvement Act should be expanded to all the market. Look, they're referencing this work by NIST. They have put together this proposed bill. Again, it's just to show you kind of the overall trend we're seeing. This is certainly top of mind for regulators, and we will see how that will develop. One of the interesting things to highlight on the bill is the definition of the device is already different in the California and Oregon law. It builds upon the NIST definition, but adds this new concept of embedded system. There is a very strong focus on leveraging standards, and certainly, you know, this would continue to develop. Brings me to the NIST. I think, you know, if there is one key takeaway for the technical audience here with us in the room is not only is this evolving, there is an opportunity for innovations, and there is a very important conversation happening on the kind of baseline foundational security capabilities horizontal to all devices. This is NIST 8259 released by NIST. There is now a federal profile in draft as well. But on the left here, this is all of industry coming together, the C2 consensus effort to provide commentary. And you can see here the trade associations. This is, you know, generally, I would say probably the entire technology sector, everyone from the US Chamber through BSA and ITI, you know, contributing to this document, real leadership by the Council to Secure the Digital Economy as feedback. And with that, I'm going to skip here. I'm going to invite Anait. Anait, please walk us through this key document in NIST.
Thank you, Amit. So let's take a closer look to the NIST and this 8259, right? What is it about? And first, let's understand the motivation and objectives, as it very well exemplifies the regulatory momentum as well. So what is this about? So 8259 targets manufacturers on the left side. Specifically, the subject of the recommendation frame around the finished IoT device, and it provides the recommendation on cybersecurity activities and the capabilities to address the customer's cybersecurity needs. So NIST publication proposes to normalize the manufacturer-customer relationship by leveraging the laws, regulation, and the guidelines. Here we need to set the expectations right. And so 8259 is intended to address a very broad range of IoT devices, right? From tiny little doorknobs to very complex critical infrastructure devices. So expect to see what I would call a lowest common denominator. And it is also important to note that all other parts of IoT ecosystem other than IoT device, right, are outside of the scope of the NIST recommendation, right? So the first step towards the making IoT security, this is the first step towards making the IoT security is measurable. It is expected that eventually more guidelines will be defined. You heard about the federal profile, I made mention about it. So this is the precursor for all these market specific profiles, right? And risk-based management recommendation that basically evolved from 8259, right? NIST emphasizes the message that IoT security should start early on. So let's look at this recommended action for the customers. Again, remember, this is about the manufacturers. And this is, it's proposed that IoT device manufacturers need to perform actions and provide the services to the customers very early on. Specifically, 8259 identified 6 specific actions, pre-market and post-market. And the first 2 activities assume that manufacturers have to have full disclosure on device usages and security goals. So this might be quite challenging as there are cases when manufacturers don't know how device might be used in field. Activity number 3 is the anchor point for the core baseline capabilities. These capabilities are defined by 8259A and supposed to address what customers would need to achieve their goals and fulfill their requirements. This is the most technically loaded part of 8259 proposal. Activity 4 covers the support. So again, manufacturers should consider the business resources required to support development and the continued maintenance of IoT devices. This includes the secure code practices, vulnerability response, and the flaw remediation. Post-market, we have 2 steps here related to communication. Although it's called out as a post-market, but I believe this is something that needs to be considered early on during the design of the product itself. So some of the examples are lifespan expectation, software updates, and a device retirement, right, and end of life. So we just talk about, right, decommissioning, what happens after the life. The main takeaway, NIST attempts to frame the security actions around the different stages of IoT device lifecycle, bridging manufacturers with the customers, and specifically they call out that at pre-market, at development stage, the core capabilities need to be addressed. So with that, let's drill down at the core baseline capabilities. There was a question on how this partnership is happening in industry. You can see here the list of multiple cross-industry IoT security activities. So NIST conducted extensive analysis of all these cross-industry guidelines covering government, alliances, trade association sector. And as Amit mentioned, we at Intel focus specifically around that C2 consensus, right? The industry-wide coordinated efforts to define foundational capabilities. As a result of all this analysis, NIST 8259A proposed the cybersecurity baseline capabilities that are mapped to existing industry-provided guidelines. Let's take a closer look. Here you see 6 capabilities outlined in 8259. This is baseline. This is starting point. This is setting the direction, and it's still going to be open for interpretation. Therefore, from the practical standpoint, at each implementation point, you will find some superset capabilities that might better fit the needs of specific market segment addressing the risk of that use cases and that class of devices. Authorized entities are the anchoring point for these capabilities. So the first one is device identification, both logical and the physical. Second is device configuration that needs to be performed by the authorized entities, and data protection. We talked about that early on. It is well known, right? The concept, the protection of data from unauthorized access modification, logical access to interfaces. It's about restriction of logical access to local and network interfaces to authorized entities only. Software updates, known bottleneck for IoT space, and the software update recommends IoT devices software being updated again by authorized entities only using secure and configurable mechanisms. And the last but not least is the cybersecurity state awareness. These capabilities about the ability of IoT device to report the cybersecurity state and make the information accessible to authorized entities. This was just a quick run through this capability. There are many nuances, the baseline definitions, so I would recommend reading through the document directly. But at this moment, let's switch the gear and look at what's left out of the NIST scope. So we did talk about the complexity of IoT ecosystem when we were talking about the uniqueness. NIST simplified the ecosystem model to two entities only. We at Intel realized that the truly deployable IoT solution requires more complex relationship. When we think about Intel, we think about the silicon, and which would be at the very left side of the slide, right? It's our partner ecosystem that builds out the rest of the story. The analogy that we like to use is the orchestra playing together, and each player has a critical role in delivering a finished symphony to the audience. The value chain goes from the ingredient to the manufacturers, OEM, ODMs, then through the ISV, service provider, solution integrators, and get delivered to the end user. So all the performers participating in the security baseline symphony, they have to play in a unison. So we need to be cognizant of that fact that the real life, right, of the products maybe starts at the field when it is already deployed, when it will be going through the circular stages of the update. And again, manufacturers rely on the rest of the ecosystem to deliver those updates. So what do we do? As we realized that we have to work with the broad ecosystem, we established our partnership. The Solution Alliance is our Intel partnership framework, and it covers over 6,000 solutions. We have more than 500 members, and of course, we work across the globe throughout our global platform. As Amit mentioned, the global interaction in the policy regulation space is critical. Our member companies span the globe and offer their local expertise in the market worldwide. This is the community that we are closely collaborating on security as well. For security discussion, it's important to establish the common ground, the common language when we are talking with the ecosystem. And for the cybersecurity, this attack surface and threat models is the common ground that we use to build our collaboration. This is where we will provide a solution to address this, right? This is how you can measure and you can make it meaningful for the end customer, as well as the response to regulatory landscape. Let's take a closer look to this eye chart. This is the attack surface map that sums up the penetration points, otherwise known as attack vectors, right? A summary of exploitable vulnerabilities at device level is presented on the right side of this table, along with the respective attack surfaces on the left side. The attacks in the top layers have been prevalent for quite some time. This is known from the PC space from the traditional compute device side, right? But the attacks are more and more getting more complex, and they moving down the stack, exploiting vulnerabilities in the firmware and even hardware level layer as well, but could potentially give higher privileges on the device and go fairly undetected.
So Anahit, I think we're roughly 10 minutes before the hour.
Yes,
So
I'll wrap up.
if you
Yeah.
could wrap up, and then we can have a few questions, okay?
Absolutely. So the main takeaway here is that attacks are not singular, right? And problem spans across the entire stack. So requires protection at each level. So the baseline capabilities that Nis was talking about, setting the stage, right, needs to be explored from this framework perspective, and this framework will allow to systematically analyze the solution and mitigate. We work with our customers on the taxonomy. We will provide innovation on hardware technologies to build a defense in depth from bottom up and withstand this attack propagation, enable the customers to address the policy needs. But this is not only about the technology side. Again, this is the response. So I would like Amit to give her perspective about the policy side, right?
Yeah, I think, thank you so much, Anait. And it's always such a joy collaborating with you. Usually when I speak with hackers, sometimes it's my sister Karen, and she's a friendly hacker, and I just love working with you and with the security researchers community. So I think this is the main takeaway. I mean, you've seen the complexities, you have seen how this specific conversation around IoT is one that is evolving, and it's not just evolving technically in terms of the verticals, in terms of the attack surface. It's top of mind for regulators. By the way, as they're considering regulation, they're actually naming specific attacks that motivate them to legislate in a specific area. And I think, for this community, collaboration is the main takeaway. And it's not just going to be about the innovations that we are driving, in the silicon to support the capabilities. It's also about how companies are collaborating with external researchers that are exploring and finding potential vulnerabilities in products. I mentioned this issue of, enabling the ecosystem, leveraging the expertise of the ecosystem. This is an area where we are working very closely with external researchers, both through the bug bounty, but both through academic collaborations through Intel Labs. And it's also going to be a collaboration as we're considering the policy landscape. It's going to require a lot of conversations, with our customers, but also between people like you and engineers and lawyers and policymakers and people that are considering policies in this area to kind of really understand the nuance of regulating this space. So with that, this has been a pleasure. Thank you so much, Anait. We are here for your questions, and I hope you enjoyed our presentation.
Yeah. Okay, no, let me thank you. I think both your presentations and the ones from Martin and Jennifer were absolutely terrific. They actually covered what we hoped we could cover today. So let me sort of ask one question, and then I have a couple to read. When I look at the IoT landscape, it's vast, and I think both of your presentations recognize that. And when you start looking at businesses that claim they're in the IoT space, and they conduct surveys, I would say almost uniformly over the last 2 years, the number one concern from adopters has been security and privacy issues. Okay, sort of fear of what does it take to actually deploy a solution. Okay, so that's one part of what seems to come through. The other one, which is which I see some inkling of from I think both presentations, is just how vast the space IoT is. So when you start looking at manufacturers, in some ways, you start looking at what are all the components somebody puts into a solution, what are all the variations of those. And when you start counting, what you may find is you have well over 10 million components that you'll have to consider. I mean, it's just that vast a space. Okay? Includes almost every vertical. Okay, so how? And I'm curious from both of our speakers, how would you slice and dice this space so one can in fact sort of create islands of activity where the results can be homogenized in terms of here is the application that applies to this form of IoT. Here is an application that applies to another form of IoT. And here is a construct that will provide security for one part of IoT as opposed to another. Okay, and it sort of feeds into a question that Anil Kripalani asked, which he asked before. So if you look at something like smart cities, you look around the world, who is really sort of the hub of activity where companies like Intel are going to go to figure out what that homogenization actually means, okay? So it's a long question, but I'd be curious to get a response from both of the teams on that.
Yeah, I can respond in terms of from a legal framework I would see around that, around those issues. Forget putting the technology to the side for a moment and how that would be homogenized. I mean, to me, you would have to, with all the participants, come up with some kind of contractual. I mean, the way I would see it sort of playing out would be through contractual obligations and agreements between the different, sort of stakeholders that are involved in the IoT or in that whole landscape of like a smart city.
So
I wouldn't.
So Marty, let me give you a concrete example. If you fly in an aircraft today that's a scheduled airline, it'll operate under national rules, but it'll also operate under IATA rules. Okay. Power plants, there's the IEEE. There's actually machinery. What I don't see on the landscape right now is any machinery to deal with the IoT world, okay, in some sensible way.
Again, if you're talking about from a sort of a global standpoint, I don't think you're going to see well, look, we've seen some, for example, in the privacy space with Privacy Shield, and we've seen some, agreements, cross-border type agreements to deal with the kinds of maybe issues that you're talking about on an airplane, for example. And, that was recently invalidated. And now,
absolutely,
now they're kind of starting over again. So I kind of have to drop one level down from relying on those kinds of regimes to deal with those issues and go back to what I have control over, which is drafting provisions in a contract between all the stakeholders and all the players that are going to be. And when we see how broad it is from the other presentation, but some kind of framework in terms of contractual rights to me is the way that I would suggest we would have to deal with something like that, unless there's some global organization that might be devising some kind of standards that would apply to that kind of situation. But yeah, as far as I know, I'm not aware of it at this point.
Yeah, Amit, your take on this?
Yeah, I would just say again to our previous presentation. First, if let's separate innovation and policy. From a policy perspective, this is exactly the reason why the horizontal efforts on the baseline conversation that are not just happening in the US, they're happening also at ISO IEC, at that level of, fundamental security standards. This is why they're critical, because we have this understanding of the baseline security capabilities are horizontal to all IoT devices and ecosystems, right? And then we develop specific profiles, right, for certain verticals. So if you open up the NIST link that I provided, they actually have a kind of an overview, and they explain how the horizontal baseline security and privacy conversation that is, attempting to encompass the whole market is going to basically be a continuation of our efforts with specific verticals. And we see already specific standards like, at CTA, at ETSI, at ISO IEC for SE41, SE27 for specific verticals. The other piece of the puzzle is just innovation to support interoperabilities, because we have, onboarding of devices. So for example, one of the innovations that we at Intel are really working with the community with in FIDO Alliance is this notion of secure device onboarding. So with the proliferation of devices, how can you more securely onboard devices? This is just one example. So we recognize we're going to have a lot of devices. We need to have both standards and innovations to work together to support this issue.
Yeah.
And maybe to add to it, don't expect like one size fit all, right, type of solution. It will never happen, right, in IoT space. By the way, the airplane example, airplane is also considered the IoT.
Well, so that's actually the point. All of a sudden that's drawn into the IoT world. All of our smartphones are used as fundamental elements in IoT solutions. And each of those happens to have its own regime of how it deals with these issues, okay? So when I start looking at it, and I think somebody, in fact, asked this as a question, is once you start doing profiles, they really make this whole issue of timely interoperability very, very difficult, okay? So how do you get by that? Okay? Because you also have sort of a societal aspect to this, where people are, openly distrusting technology, maybe not for rational reasons, okay, but somehow the assurance has to be built in. It's not that you pass the rules, but somehow the education and communication has to go along with this.
Well, that's partly why you see a lot of emphasis on, notice and consent, and, opt in, not opt out, and the way that a lot of the privacy and data protection laws are getting implemented, so that there's a lot of transparency about how your individual data is being used, and that it's not going to be used or sold to third parties and used in other ways without you knowing about it and being, providing consent. I mean, we don't have that across the board, and maybe that's part of the standards that need to be implemented to regain the public trust.
Yeah. So let me do the following. I think to honor everybody's time, we're sort of a few minutes actually past the hour. I suspect we could probably go on with the conversation for another hour or so. But literally, let me thank you for putting together those presentations. I think they were absolutely informative and terrific. I think you had a good audience today. Actually, strangely, we tend to get more people than if we were to do this in a small face-to-face meeting. And then lastly, let me just say that the IoT initiative for IEEE is very interested in this area. And we hope you both are willing to participate in that. We have a lot more things in the chute. And let me just do a plug. We have a vertical and topical week coming up September 14th, and then a Women in Engineering panel on the 23rd of September. I think just looking at the registration numbers, that's about to set a record for us. So with that, let me thank you all, and I hope you enjoyed this and continue to participate. Thank you.
Absolutely.
Thank you very much. Thank you.
Thank you.
Thank you.
Thank you on behalf of IEEE as well. It was a wonderful session. Take care.
Thank you.